Next, I'm going to do bifurcated trials. So just in case anyone is watching this that isn't sure exactly what a bifurcated trial is, I'm going to explain what it is. So let's say I'm riding my bike or something and I get into an accident with a driver. So now I'm like trying to sue this driver for my injuries, and they're like, it was your fault, you rode out in front of me in the first place, like I don't have any liability. And I'm like, no, yes you do, you fucking like hit me. So the bottom line is, even if I can prove that I was really, really injured and like totally fucked up, okay, if it wasn't the driver's fault, like if the jury is going to find that the driver wasn't liable, then why should I waste the jury's time talking about how injured I am and my damages, when really, if the jury finds that the driver isn't liable, then it's irrelevant about my damages. So in the interest of economy, courts are encouraged to order bifurcated trials. So because of this, if they're going to have a bifurcated trial, and it's unless the court orders otherwise, the issue of liability shall be tried first, unless the court orders otherwise. And that makes sense because, again, if the jury finds that it was my fault and I rode my bike out in front of in the street in the middle of the road or something, and that the driver isn't liable, then the trial's over. We don't have to waste the jury's time talking about my damages. So now the first thing it does is talks about the voir dire rules. So if the jury that sits for the trial is also going to sit for the second part of the trial, the damages part of the trial, my lawyer has to be allowed to ask the jury questions relating to damages. Like, I don't know what those would be because I'm not a lawyer, but apparently, like, you would ask those kind of questions, and you have to be allowed to do it if the jury is going to be the same jury sitting for both phases of the trial. Now, during the liability phase of the trial, the lawyer, like my lawyer, is not allowed to talk about damages. They're not allowed to argue it, and it's only after the driver is found liable that they can begin arguing about my damages. And generally, unless the court finds it to be impracticable, whatever that word is, impracticable, we're going to go over the whole article, like, writing after this. But unless the court finds it to be impracticable, and if there's a verdict for the driver on their counterclaim, or for me, the bicyclist, on my claim, then immediately we go into the damages phase of the trial, and counsel has to be afforded an opportunity to discuss that in front of the jury, to basically make another opening. So in their original opening statement, counsel is not allowed to discuss damages when there's a bifurcated trial. They're not allowed to. It's only after the jury finds, either from the cyclist or the driver on a counterclaim, then they're allowed to then argue about damages. They're basically allowed to get a second opening. Also, this kind of like protects defendants in a way, because sometimes you can't really trust juries to actually listen to the evidence. So like, let's say the jury hears all this testimony, or my lawyer's allowed to argue in their opening that, like, you know, and I was like into biking and I loved hiking and that was my whole life, and then now I got hit by a car, I'm on my bike and I'm all fucked up and I can't go hiking anymore because I'm injured. Like, the jury might honestly just ignore some of the evidence and just feel bad for me and like give me a verdict, when it really doesn't protect the defendant from sympathetic jurors. So by bifurcating the trial, only doing liability first, not being allowed to discuss damages, the jury is really only looking at whose fault was the accident, and then when they decide, without hearing anything that's going to cause maybe sympathy about how I can't walk anymore or whatever, they then will hear about all my injuries and everything. So it makes it a little bit more fair that they're only looking at the actual facts of who caused the accident, whose fault was it. So, again, just remember, bifurcated trial, the issue of liability is always going to be first unless the court orders otherwise. Counsel cannot argue about damages in their opening statement, but if the verdict is for the plaintiff or defendant on a counterclaim, then they both get an opportunity to make a second opening statement where they can talk about damages. And it's always going to be in front of the same jury unless it's impracticable.
202.42 Bifurcated Trials. A. Judges are encouraged to order a bifurcated trial of the issues of liability and damages in any action for personal injury where it appears that bifurcation may assist in a clarification or simplification of issues and a fair and more expeditious resolution of the action. B. Where a bifurcated trial is ordered, the issue of liability and damage shall be severed, and the issue of liability shall be tried first unless court orders otherwise. C. During the voir dire conducted prior to liability phase of the trial, if the damage phase is to be conducted before the same jury, counsel may question the prospective jurors with respect to issue of damages in the same manner as if the trial were not bifurcated. D. In opening to the jury on the liability phase, counsel may not discuss the question of damages. However, if verdict of the jury shall be in favor of the plaintiff on the liability issue or in favor of defendant on any counterclaim on liability issue, all parties shall then be afforded an opportunity to address the jury on the question of damages before proof in that regard is presented to the jury. E. In the event of a plaintiff's verdict on the issue of liability or defendant's verdict on a counterclaim for liability, the damage phase of the trial shall be conducted immediately thereafter before the same judge and jury, unless the judge presiding over the trial, for reasons stated in the record, finds such procedures to be impracticable.